At 5:02 a.m., the first knock hit the front door like someone using the wood itself as an announcement. I was awake already. I'd been awake since 4, sitting at the kitchen table with my laptop open, but not on. Insomnia didn't feel like a symptom that morning. It felt like a warning system that had started working again after months of neglect. The second knock came before I could stand. Measured. Patient. The kind of knock that assumed the door would open because the person behind it had a reason the law recognized. I checked the clock, then the camera feed on my phone. The porch light showed a sheriff's deputy standing slightly to the side of the door, hands visible, a folder tucked under his arm. Another uniform was 2 steps behind him, just off the walkway, body angled toward the street. I didn't open the door right away. I put on shoes like that mattered, then crossed the living room and unlatched the deadbolt. When I opened the door, the cold air came in first. The deputy's eyes went to the house number, then back to me, the way someone checks a label on a file they've already decided belongs to you. "Morning," he said. It wasn't friendly. It wasn't hostile either. It was procedural. "Morning," I said. He held up the folder. "You're Daniel Mercer?" "Yes." He pulled out a stapled packet, already clipped to a bright yellow sheet. "We have a writ of possession, eviction order, effective today." I didn't reach for it. "For this address?" "Yes." He looked down at the top page, reading as if the words were a script he was obligated to honor. "Property at 118 South Waverly. You're listed as occupant. Owner of record is." He paused for a fraction of a second, then continued. "Owner of record is Elaine Mercer. My mother's name." My eyes went to the street behind them, still dark. No moving trucks. No landlord, no neighbors. Just 2 deputies and paper. "That's not possible," I said carefully. "This house is in my name." The deputy didn't react to that the way people do when they hear something impossible. He reacted the way people do when they hear something common. He shifted his grip on the folder and extended the packet again. "Sir," he said, "I'm not here to debate ownership. I'm here to execute a court order. You can call the number on the last page for the court clerk. But the writ is valid, signed by a judge. We'll be back at 8 with a locksmith if you're not out." 8. Less than 3 hours. The second deputy spoke for the first time, voice quiet. "You can take what you need. Medications, documents, essentials. We can't stop the writ." I took the packet. The pages were crisp, freshly printed. It smelled like toner. "Who filed this?" I asked. The first deputy nodded toward the paperwork. "It's in there. I'm going to advise you to read it." I stepped back inside and shut the door, leaving the chain off. I stood in the entryway with the packet in both hands like it was something that could stain me. The top page was titled Writ of Possession. County seal. Case number. A signature that looked like a signature, and a clerk stamp that looked like someone had pressed it hard. Plaintiff Elaine Mercer. Defendant/occupant Daniel Mercer. Property 118 South Waverly. Basis: unlawful detainer following foreclosure and transfer. Foreclosure. I turned pages too fast at first, flipping through words that didn't connect to my life. Trustee's deed, notice of default, substituted trustee, acceleration clause. My mind tried to anchor to anything familiar, and the only familiar thing was the name printed again and again on lines labeled borrower. My name. Daniel Mercer. Borrower. The writ referenced a deed of trust I had never signed and a loan amount I had never received. It also referenced a quitclaim deed transferring the property from me to Elaine Mercer, recorded 9 months earlier. 9 months. I went to my desk drawer where I kept a file folder labeled House, the place I put documents so I could tell myself I was organized. I pulled out my closing papers from 5 years ago, the deed, the title policy, my mortgage statement showing my last payment cleared 2 weeks ago. I opened my laptop and logged into my mortgage account. It showed current. No notices. No warnings. No foreclosure. I read the writ again, slower. It listed a lender I recognized in name only, not my lender. It listed a trustee company I'd never heard of. It had a legal description of the property that matched my deed. There was a recorded document number for the quitclaim deed, another for the deed of trust, another for the trustee's deed upon sale. Recorded. That word mattered. Recorded meant someone at the county had accepted paper and entered it into the system that makes fiction look like ownership. My phone buzzed while I stared at the screen. A text from my mother. Are you awake? Call me when you can. It was 5:11 a.m. She didn't text like that, unless she wanted to control the timing of something. I didn't call her. I opened the county recorder's online search portal. It was slow, designed like a museum exhibit of early internet, but it worked. I typed my address. A list of records loaded. The first page showed my original deed, then a refinance I'd never done. Then the quitclaim deed, then the deed of trust, then the trustee's deed, all with dates and document numbers, all accepted, all sitting in the public record like they'd been there forever. My hands didn't shake, not because I was calm, but because shaking is what you do when your body believes something can be fought physically. This wasn't that kind of threat. It was already inside the system. At 5:19, I called the number on the last page of the writ. An automated message said the court clerk's office opened at 8:30 a.m. The writ would be executed at 8. I called the after-hours line for the county legal aid hotline. It went to voicemail. I called my mortgage lender's customer service. After 3 prompts and 2 holds, a tired voice came on. Mortgage servicing, this is Carla. My name is Daniel Mercer, I said. I have an eviction writ claiming this property was foreclosed. My mortgage account shows current. I need to confirm if there's any foreclosure action on your end. She asked for my last 4. I gave it. She pulled up my account. I see you're current, she said. There's no foreclosure in process with us. Have you sold the loan? No. It's still serviced here. The writ lists a different lender and trustee, I said. I can't speak to that, she said, then hesitated. Sir, if you think there's fraud, you should file a police report and contact your county recorder. We only control our lien. I need to stop an eviction in under 3 hours, I said. Carla exhaled, like she wanted to tell me the truth but didn't have a script for it. I'm sorry, I don't have a way to stop a sheriff's writ. I hung up and stared at the county records again. The quitclaim deed showed my name as grantor, my mother's as grantee. It listed a notary. It listed a notarization date that corresponded to a weekend I remembered, because I was out of town at a work conference, a photo of me in a group dinner still sitting on my phone. I clicked the document image. It loaded slowly, then resolved into a scanned PDF. My signature was there. It looked like mine, the way counterfeit money looks like money to someone who doesn't handle it often. It had the right letters, the right slant, but the pressure points were wrong. The loops were too round. The last stroke was too neat. I'd spent years signing contracts at work. I knew my own hand. This wasn't it. I scrolled down. The notary block had a stamp and a signature, the notary's commission number, a county. There was also a second page, a deed of trust, with my name again, borrowing against the property, using it as collateral for a loan. The lender name was not mine. The signatures matched the quitclaim, same fake hand, same notary. A third document, substitution of trustee. Then the trustee's deed, sold at auction, transferred to my mother. My mother had moved the house into her name, borrowed against it, defaulted, then ended up with the house again after a trustee's sale, all on paper. The paperwork described a cycle where I was the borrower, the transferor, the occupant, the problem. And now, at 8, I was supposed to walk out with a bag. My phone buzzed again. Another text. Daniel, please call me, it's important. There are ways people steal property. I knew that in an abstract sense. It's in news articles, podcasts, cautionary advice, monitor your title, freeze your credit, watch for scams. I'd never connected it to family. The mental category for threat doesn't usually include the person who taught you to ride a bike. I went to my safe, a small fire-resistant box in the closet. Inside were passports, birth certificate, my original deed, and a handful of documents I didn't want floating in drawers. I pulled out my passport and my old driver's license. Then I grabbed my current license from my wallet. If someone forged my signature, they might have used my old ID or copied a signature from something. That didn't matter yet. What mattered was stopping the eviction. At 5:37, I called the sheriff's office main line. It routed to dispatch. A calm dispatcher answered. I was served a writ of possession, I said. I believe the underlying documents are fraudulent. I need to know what I can do before 8. The dispatcher asked for the case number. I read it. She put me on hold for 30 seconds. Then a different voice came on, deeper, older. This is Sergeant Tolan. I repeated my situation. I kept my voice even. I avoided accusations that sounded emotional. I can show proof I'm current on my mortgage. I can show I was out of town on the notarization date. The signature on the deed isn't mine. The plaintiff is my mother. Tolan didn't respond to my mother. He responded to not mine. Do you have a police report number? He asked. No, I said. I'm calling now because the lockout is scheduled for 8. Sir, we execute rights issued by the court, he said. If you believe it's fraud, you need an emergency order from the judge staying the writ. Without that, we proceed. How do I get an emergency order before 8? I asked. Silence long enough to be meaningful. The courthouse opens at 8:30, he said. You can try the on-call judge line, but that's typically for protective orders and criminal matters. Civil isn't staffed after hours. So there's no mechanism, I said, not as a complaint, as a statement. There's a mechanism, he said. It's just not fast. I thanked him and hung up. At 5:52, I called an attorney I'd used once years ago for a contract issue. He answered on the third ring, voice thick with sleep. Dan? I'm sorry, I said. I need help. I'm being evicted at 8. It's based on forged documents. He didn't ask how. He asked when. 8 today. Yes. Send me everything, he said. Email and text. I'm getting up. I sent him photos of the writ and links to the recorded documents. Then I sat down and forced myself to think like I was writing a report, not living in it. Facts. Time of service, 5:02 a.m. Lockout scheduled 8 a.m. Plaintiff, Elaine Mercer. Recorded quitclaim deed 9 months ago. Notary, name, commission number, mortgage account, current with my lender, no foreclosure. Next step, courthouse the moment it opens. File emergency motion to stay execution, present evidence of fraud, get judge signature, deliver to sheriff before lockout if possible. But the courthouse opened at 8:30. The lockout was at 8. Unless the deputies waited, unless there was discretion. Discretion is rare in systems that rely on paper, but sometimes it exists in the seams. At 6007, I called the deputy's number printed on the writ packet. It went to voicemail. I left a message with the case number, my name, and one sentence. I have evidence the underlying recorded documents are forged, and I'm current on my mortgage. Please call me before 8. Then I did something I hadn't wanted to do. I called my mother. She answered immediately, like she'd been holding the phone. Daniel, she said. Thank God. I was served an eviction writ, I said. Your name is on it. A pause controlled. I know. I was going to explain. How are you the owner of my house? I asked. It's complicated, she said. It's not, I said. It's recorded, a quitclaim deed, a deed of trust, and a trustee's deed. My signature is on it. I didn't sign it. Her breath came through the line, then a sound like she was shifting in bed. You're upset, I understand. Did you forge my signature? I asked. Another pause. Not shocked, not offended, just cautious. Your father and I have been dealing with things, she said. We had to protect the family. You used my house, I said. You transferred it into your name. Temporarily, she said. It was never meant to hurt you. It's hurting me right now, I said. The sheriff is coming at 8. I'm trying to stop it, she said quickly. I called someone yesterday. There was a mistake with the paperwork. It's a misunderstanding. A misunderstanding doesn't produce a notarized signature, I said. Who is the notary? I don't know, she said. You don't know the notary that stamped a deed transferring my property, I asked. Daniel, please, she said, and her voice changed slightly, becoming the voice she used when I was a teenager and she wanted the conversation to end without resolution. If you just come over, we can talk. Bring the papers. I'm not bringing the papers, I said. I'm bringing them to court. If you do that, she said, and the calm cracked just enough to show the steel under it, you'll embarrass your father. People will find out things that don't need to be public. It's recorded, I said. It's already public. She didn't answer. I ended the call. I didn't slam the phone down. I just tapped the screen and stared at the black glass. At 6:31, my attorney called back. I'm looking at the county images, he said. This is classic. It's not sophisticated, but it's effective because the recorder's office doesn't verify signatures. They record what's presented. Can we stop it before 8? I asked. He didn't lie. I can try to call the plaintiff's attorney in the sheriff's civil unit and ask for a voluntary hold, but without a court stay they don't have to. Plaintiff's attorney? I asked. He read a name from the docket. A firm downtown. They file evictions all day. Call them, I said. I will, he said. Also, take screenshots of everything. Download the document images. If they lock you out, you'll still need access to proof. At 6:40, I started downloading. The county site watermarked each PDF, but that didn't matter. The content mattered. I saved them to a folder, then emailed them to myself, then uploaded them to cloud storage. Redundant. Quiet panic expressed through backups. At 7,005, my phone rang. It was an unknown number, I answered. This is Deputy Larkin, a voice said. The first deputy from my porch. Yes, I said. Thank you for calling back. I got your message, he said. You're claiming fraud. I'm claiming the recorded documents are forged, and the foreclosure is not tied to my actual lender, I said. I can provide proof. I'm not a judge, he said. I know, I said, but if you execute the writ and it's fraudulent, you're putting me out of my home based on a crime. He didn't respond to the moral part. He responded to the operational part. Do you have a court order staying the writ? No, I said. The courthouse isn't open. Then we execute, he said, then hesitated. But I can tell you this. If you can show me something that makes the right questionable, I can call my sergeant and ask for direction. Come now, I said. Before 8, I can show you my mortgage account, my deed, and that I was out of town on the notarization date. He didn't agree immediately. Then I'll be there in 15. At 7:21, I heard a car door outside. I opened the door before he knocked, not to be helpful, but because time was a shrinking corridor. Larkin stood on the porch alone this time. No second deputy. He held the folder again, but his posture was different, less final. Show me, he said. I led him to the kitchen table. I didn't offer coffee. This wasn't hospitality. It was evidence presentation. I opened my laptop to my mortgage account. This is my lender, I said, current, no foreclosure. He leaned in slightly, reading. This isn't the lender listed in the writ. Correct, I said. Here is my original deed, recorded 5 years ago. I placed it beside the printed county image of the quitclaim deed. 2 deeds. 2 realities. He looked at the signatures. That's supposed to be yours. Yes, I said. It's close, he said. It's not, I said, but that's not the key flaw. The key flaw is the notary. I pointed to the notary block. This notary notarized my signature on a date I wasn't in town. I can prove it with work records, but more importantly, the notary is a point of verification. Larkin straightened. You have proof you weren't in town. I can show you my hotel receipt and a photo timestamp, I said. I can also show you my badge access logs at my workplace were not used that day, but the real proof will be the notary journal and any surveillance at the location where the notarization allegedly occurred. He nodded, slow. Who is the plaintiff? My mother, I said. He didn't show surprise. He just made a note. Okay, I handed him my phone with a screenshot of the county record list. These documents were recorded. That's how this got into court. He looked at me. You understand that even if all this is true, I still need direction. If my sergeant tells me to execute, I execute. I understand, I said. I'm asking you to make the call with this information. He stepped aside and dialed. He spoke quietly on the porch. I caught pieces. Claiming fraud, mother is plaintiff. Mortgage current with different lender, notary issue, no stay order. He came back in. My sergeant wants you to come to the station right now, he said. Bring your ID and what you have. He says there may be a way to delay based on a fraud report, but it's not guaranteed. We need to document it. Will you still come at 8? I asked. He held my eyes. If we don't have direction otherwise, yes. I grabbed a folder, shoved in my deed, my mortgage statement, printouts of the county documents, and my passport. I locked the house and followed him in my car to the station, leaving my home behind while it was still legally mine, and might not be in an hour. At the sheriff's station, the front desk looked like every public building: bulletproof glass, a tray for documents, a sign about weapons. Larkin waved me through to a small interview room that smelled like disinfectant and old coffee. Sergeant Tolan came in 5 minutes later. He was in uniform, but without the calm politeness of a patrol deputy. He sat down, placed a notepad on the table, and looked at me like he was measuring whether I understood what words cost in a report. Mr. Mercer, he said, you're alleging that someone recorded fraudulent deeds against your property and obtained a writ of possession. Yes, I said. Your mother is the plaintiff, he said. Yes. He didn't ask why. He asked for sequence. When did you learn about the deed transfers? Today, I said, at 5 a.m. He nodded. Okay, we're going to do 2 things at once. 1, we'll take a report for suspected forgery and fraudulent filing. 2, I'm going to call civil and ask for a brief hold pending review. I can't promise it. How long, I asked, is a brief hold? He looked at his watch. If I can get it, it's hours, not days. You still need a court order. Hours could get me to a courthouse. Tolan started the report. He asked for dates, names, document numbers. I gave them. He asked for my mother's address. I gave it. He asked if I'd given her power of attorney. I hadn't. He asked if I'd signed anything. I hadn't. He asked for a sample of my signature. I signed a blank line on his notepad. Then I signed again on a separate sheet, slowly, then quickly, then how I normally do. He compared the samples to the county images. His face didn't change, but the way he held the paper did. It wasn't disbelief. It was recognition of pattern. Notary name, he said. I gave it. He stood and left the room. Through the small window, I saw him walk to a desk area and make a call. Minutes passed with nothing to do but listen to the air conditioner and stare at the framed poster about community policing. The poster promised partnership. The room promised containment. Tolan came back in. Civil will delay the lockout, he said. 2 hours. That's it. They'll document that you've filed a fraud report and are seeking emergency relief. What about my property, I asked, in the meantime? The writ is still active, he said, but they will not execute at 8. You have until 10. 10. The word landed like a weight and a gift at the same time. Thank you, I said. He nodded once. Don't thank me yet. If you don't get a stay by 10, they execute. At 7:58, I was back in my car, driving toward the courthouse. The sun was coming up, turning the strip malls and office parks into normal places again. Normality felt obscene. My life was being rewritten in county records and a courtroom schedule, and the world was still ordering breakfast. My attorney met me outside the courthouse at 8:12. He was in a rumpled suit, holding a portable printer box under one arm, like he'd grabbed whatever could turn data into paper. Civil delayed to 10, I told him. Good, he said. That's enough to get in front of someone. The courthouse doors opened at 8:30 exactly. There's a particular sound when public buildings unlock, the click that says the system is now available for business. We went through security. I carried my folder like it was evidence in my own trial, because it was. At the clerk's counter, my attorney spoke in the language clerks respond to: motions, emergency relief, ex parte request, stay of writ, fraud in the inducement, forged deed, irreparable harm. The clerk's face stayed neutral. Neutrality is a skill developed by anyone who sees panic daily. She handed us forms and a number. "You'll need to file in the same case," she said, tapping the case number on the writ. "You can request an emergency hearing. Judge Garvey is on the civil calendar today." "How soon?" my attorney asked. She shrugged. "Depends on the judge." We filed. We paid a fee. We waited. At 9:77, my phone buzzed. A call from my mother again. I didn't answer. I watched the hallway outside the courtroom, the flow of people holding folders, the quiet desperation in suits and work boots. At 9:19, a bailiff opened the courtroom door and called the case number. It wasn't our eviction case. It was something else. A motion about child support. A landlord-tenant dispute. A restraining order. Life as paperwork. At 9:34, the bailiff called our case number. My attorney stood. That's us. Inside, the courtroom was smaller than I expected. Less theatrical. The judge sat behind a bench with a computer monitor angled toward him. A clerk sat to the side. No jury. No audience besides people waiting. The air smelled like old carpet and paper. Judge Garvey looked down at the file. "This is an emergency motion to stay a writ of possession," he said. "Yes, Your Honor," my attorney replied. My client was served at 5 a.m. Lockout was scheduled for 8. Sheriff delayed to 10 pending a fraud report. The writ is based on recorded documents that appear to be forged, including a quitclaim deed transferring title from my client to the plaintiff, Elaine Mercer. Plaintiff is his mother. The judge looked at me for the first time. His expression didn't change at mother, but his eyes held on me half a second longer than a stranger's would. "The writ was issued based on a trustee's deed," the judge said, scanning. "Foreclosure, unlawful detainer. Why wasn't this raised earlier?" "Because my client had no notice," my attorney said. "He never signed the deed of trust underlying the foreclosure. He is current on his actual mortgage with a different lender. We have documentation." The judge held out his hand. "Show me." My attorney handed him a packet. Screenshots of my mortgage account showing current status, copies of my original deed, the recorded quitclaim, the deed of trust, the trustee's deed, and the sheriff's report number. Judge Garvey examined the notary block. Then he asked one question that mattered because it wasn't moral, it was procedural. "Where was this notarization performed?" he asked. "The deed states it was notarized in this county," my attorney said. Judge Garvey leaned back slightly. "Notaries in this state are required to maintain journals," he said, mostly to himself. Then he looked at the clerk. "Do we have the plaintiff present?" The clerk checked. "No, Your Honor. Plaintiff is not present." "Any counsel for plaintiff?" the judge asked. The clerk checked again. No appearance. Judge Garvey's eyes narrowed in a way that suggested annoyance more than suspicion. "A writ of possession executed same day, and plaintiff doesn't appear for emergency hearing," he said. He turned to me. "Mr. Mercer, you are saying under oath you did not sign these documents?" "Yes," I said. "You are saying you did not transfer your property to the plaintiff?" he said. "Yes." "You are saying you did not execute this deed of trust?" he said, tapping the page. "Yes." He nodded. "I'm going to issue a temporary stay of the writ pending a further hearing. This is not a ruling on the underlying title dispute," he said. "This is to prevent irreparable harm while we sort out whether the court was misled." He looked at the clerk. "Set this for an expedited hearing within 10 days. Order plaintiff to appear. Also, I want a subpoena drafted to the notary for the journal entry corresponding to this notarization and any identification used." My attorney's posture changed. Not celebratory. Focused. The system had engaged. Judge Garvey signed the order. He signed it quickly, the way someone signs when the decision is obvious in the frame of procedure. My attorney took the signed stay order like it was oxygen. We moved fast. At 9:52, we were back in the hallway. At 9:52, we were at the clerk's window getting certified copies. At 10,003, We were in the parking lot, my attorney on the phone with the sheriff's civil unit. At 10,011, we arrived at my house. A sheriff's vehicle was already there. Deputy Larkin stood on the porch again, folder in hand, looking at his watch. My attorney walked up first, held out the certified order without speaking like a salesman, just like a person delivering a key. Larkin took it, scanned it, then looked at the signature and stamp. "This day's execution," he said. "Yes," my attorney replied, "pending further hearing." Larkin nodded, then turned slightly so his body camera captured the exchange clearly. "We are not executing the writ today," he said, voice loud enough for the record. "We'll note the stay and return the writ to the court." He handed the packet back to my attorney. Then he looked at me. "Make sure you show up to the next hearing," he said. "I will," I replied. He left without ceremony. The car door shut. The vehicle reversed down the driveway. The street returned to its ordinary stillness, but I didn't feel relief yet. A stay order doesn't fix a forged title. It just slows the damage. Inside, my attorney stood at my kitchen table again, this time laying out tasks like a project manager. "Now we go after the foundation," he said. "We need to file a separate action to quiet title and invalidate these instruments. The stay only stops eviction. It doesn't undo the recording." "What about criminal?" I asked. "We already have a report," he said. "The notary is the hinge. If the journal entry doesn't exist, if the ID doesn't match, if the signature doesn't match, that becomes evidence. Also, any attorney who filed the eviction relying on fraudulent documents has exposure." I nodded. "My mother will say it was a mistake," I said. "She can say anything," he replied, "but the records will say what happened." At 10,039, my phone rang again. My mother. This time I answered, not because I wanted to talk, but because I wanted her words on a line that would produce a call log. "Daniel," she said. "What are you doing?" "Someone from the courthouse called your father. They said we have to appear." "I filed for a stay," I said. "You didn't have to do that," she said. "We were fixing it." "You recorded a deed with my signature," I said. "That's not fixing. That's the act." "It was to keep the house safe," she said, as if the word safe could cover everything. "From what?" I asked. She hesitated. "From creditors," she said finally. "Your father's business. There were problems. We needed collateral and we couldn't qualify. We were going to pay it back. It was temporary. So you used my property because you couldn't use yours," I said. "It's family," she replied. "You would have helped." "If you'd asked," I said, "I could have decided." "You didn't ask because you needed my signature, not my consent." Her voice sharpened. "Do you understand what you're doing to us?" "I understand what was done to me," I said. "You're going to send your own parents to jail," she said, quiet now, as if she believed the quietness made it true. "I'm going to send the documents where they belong," I said. "The system decides what happens next." She didn't speak. "Then, your father is going to have a heart attack." "I'm not discussing this," I said. "Your attorney can talk to mine." She made a small sound like she wanted to say my name again, but I ended the call. My attorney looked at me. "Good," he said. "Keep it clean. No threats, no bargaining. Just process." The next 10 days were not dramatic. They were worse in a quieter way. I lived in my house under a stay order, knowing the county records still showed my mother as owner. That meant she could try to do other things. Take out another loan, sell it, file more papers, so we moved quickly. My attorney filed a lis pendens, a notice of pending action against the property. It was a simple document that did something powerful. It warned anyone searching title that the property was under litigation. It didn't change ownership, but it poisoned the marketability of the fraudulent claim. We also filed a complaint to quiet title seeking a court declaration that the quitclaim deed and subsequent instruments were void due to forgery and fraud. We named my mother, the trustee company, and the purported lender. In parallel, Sergeant Tolan called me once to confirm details. He asked for copies of my travel receipts. I provided them. He asked for any emails with my parents about the house. I had none because they hadn't asked. The notary responded to the subpoena through an attorney. The first response was a letter stating the notary's journal had been misplaced during an office relocation. Judge Garvey didn't accept that. At the expedited hearing, my mother appeared with my father and an attorney. They sat at the plaintiff's table as if they belonged there, as if sitting in the correct place could change what they had done. My mother looked at me once, then away. My father didn't look at me at all. He studied the ceiling, the judge's bench, the wall clock, anything but my face. Their attorney spoke first. He argued that the dispute was a family misunderstanding and that my mother believed she had authority to handle my property because I had always supported the family. He suggested I was overreacting, that the court should lift the stay, that possession should transfer as recorded. Judge Garvey listened without expression. Then he asked about the notary journal. "Where is the journal entry?" he asked. Their attorney said the notary could not locate it. Judge Garvey's voice stayed level. "Notaries are required by law to maintain journals," he said. "If there is no journal entry, that is not a minor issue. That is the core of the notarization. The notarization is the reason we treat a signature as authenticated." He turned to my attorney. "Do you have additional evidence?" he asked. My attorney stood. "Yes, Your Honor. We have 3 pieces of concrete proof." He held up the first. "First, my client's actual lender confirms there was no foreclosure and the mortgage is current. The foreclosure documents cite a lender with no lien on record prior to the fraudulent deed of trust. Second, we have the notary's commission status. The commission number on the recorded documents corresponds to a commission that expired 2 months before the notarization date stated on the deed." That one landed visibly. My mother's attorney stiffened. "Third, we have a certified copy of my client's passport entry stamps and hotel receipts showing he was out of state on the notarization date, as well as a time-stamped work conference photo corroborating location." The judge's gaze moved to my mother, not angry, assessing. "This court will not be used to enforce an eviction based on documents that appear fraudulent on their face," Judge Garvey said. "The stay remains. Additionally, I am referring this matter to the District Attorney's Office for review of potential forgery and false filing. I am also ordering the Recorder's Office to flag these instruments pending resolution." My mother's face changed then, not with tears, not with drama, but with calculation failing. She had believed the recorded system would protect her. She had believed the law would treat paper as truth. And it does, until the paper is questioned by the same authority that gave it power. My father finally looked at me. His expression wasn't apology. It was disbelief that I had allowed the system into the family space where he thought he ruled. Judge Garvey continued. "Mr. Mercer," he said to me, "your quiet title action will proceed. But understand this, the law is not a therapy session. It is a mechanism. Bring evidence. Keep your filings clean." "Yes, Your Honor," I said. Outside the courtroom, my mother's attorney approached my attorney. They spoke quietly. I didn't listen. I watched my parents stand near a bench in the hallway, close enough to touch, not touching. My mother walked toward me. Her steps were careful, like she knew the building had cameras and sound could be interpreted. "Daniel," she said, voice low, "you're doing this because you hate us." "I'm doing this because you forged my signature," I replied. I kept my tone flat. "Those are different things." "We raised you," she said. "I know," I said. "That's why you had access to my information." She stared at me as if she wanted me to break, to give her something loud to use later. I didn't. She turned and walked away. The decisive resolution didn't come in one cinematic moment. It came in a sequence of filings and verifications that made the fraudulent record collapse under its own weight. The district attorney's investigator contacted the notary directly. Under pressure, the notary produced a partial journal, but the entry for my deed was missing. The notary also admitted in a recorded interview that she had notarized documents for my mother without the signer present. She had accepted a photocopy of an ID. She had relied on family trust. She had stamped anyway. That admission did what emotion never could. It converted suspicion into an evidentiary path. My mother's attorney requested settlement talks. My attorney demanded a stipulated judgment, the quitclaim deed voided, the deed of trust voided, the trustee's deed voided, and my title restored in the record. Additionally, the lis pendens would remain until the recorder accepted the court's final order. My parents resisted at first. They offered partial concessions. They asked for time. They tried to frame it as an internal family transaction. The court didn't care about the framing. It cared about the chain of title and the validity of notarization. When the notary was charged with notary misconduct and referred for revocation, my parents' posture changed again. When the investigator asked to interview my mother formally, their posture changed completely. We returned to court for a status hearing. Judge Garvey reviewed a proposed stipulated order. "Elaine Mercer," he said, addressing my mother directly. "Do you understand that by signing this stipulation you are admitting that the documents transferring title were not executed by Mr. Guo, Mercer as recorded?" My mother looked at her attorney, then at the judge. Her voice was quiet. "Yes." "Do you understand that the recorder will amend the record based on this order?" he asked. "Yes," she said. "Do you understand that this does not resolve any criminal investigation?" he said. "That is separate." Her hands tightened on the table edge. "Yes," she repeated. The judge signed. The gavel didn't come down dramatically. There was just the sound of paper sliding across a desk, the clerk stamping, the system making a correction. 2 weeks later, I went to the county recorder's office in person with certified copies. The clerk behind the counter reviewed the order and nodded without emotion. "We'll process this," she said. "It'll take 3 to 5 business days." "Will the fraudulent deeds be removed?" I asked. "They won't be erased," she said, precise. "The public record keeps history, but the court order will be recorded and the indexing will reflect that the instruments are void. Title companies will see it. The chain will show the correction. History kept. Correction recorded. That was the real victory. Not a clean slate, but a documented truth. On the 5th day, I checked the online portal again. The new entry was there, Quarter Vordum in Instruments. It referenced the document numbers of the quitclaim deed, the deed of trust, and the trustee's deed, marking them as void by judgment. My name returned as owner of record. Nothing in my house changed physically. The walls didn't shift. The air didn't lighten, but the invisible layer, the one that decides who can live inside these walls, had been put back where it belonged. My mother didn't call again after that. My father sent one text. "We need to talk." I didn't respond, not because I wanted revenge. Because talking was where they were strong, records were where I was safe. I replaced my locks anyway, not because the sheriff had come, but because I had learned what access really means. I froze my credit. I signed up for property fraud alerts offered by the county. I checked my title monthly like a person checks bank statements. The system didn't save me because it was kind. It saved me because it was documented. The same machinery that made the fraud possible made the correction unavoidable once the evidence was placed in the right hands at the right time. Sometimes people ask what it felt like having your parents do that. They expect a sentence about betrayal, about rage, about grief. The truth is simpler and colder. It felt like reading my own name on a document I didn't sign and realizing that love, when mixed with entitlement, is just another method of access. I didn't win by arguing with them. I didn't win by convincing them to care. I won by moving faster than the lockout schedule, by finding the procedural flaw, by forcing the notary's missing journal entry into daylight, by getting a judge to put his signature on the only paper the sheriff recognized. If you've ever dealt with something like this property fraud, family using documents as weapons, institutions acting on paper without knowing the story, you already know how it goes. The story doesn't matter until it's attached to a case number. If you want to tell me what your system did or didn't do, you can leave it in the comments. And if you're following these stories because you want to understand how power actually shifts in real life through filings, timestamps, and records, you can subscribe. That's where the next one will be.